It has now been 3 months since the EU AI Act was put into law in the European Union. So what happens now? How does this affect the development, the distribution, and utilization of AI in Europe in the coming years? Hello, I'm Stefan. I'm the COO and Compliance Officer at the Norwegian AI automation agency Automatisering AS. And today I will talk about what EU AI Act actually means for the implementation of AI in European and related countries and how to secure EU AI Act compliance in the coming years. So first of all, why is this important and who is this important for? So this is a fairly new piece of legislation. As mentioned, it went into effect in August 2024. And even though even the prohibited activities haven't been completely banned yet, this is coming soon, and especially in the coming years, especially in 2025, in February 2025, there will be a complete ban on prohibited activities, and coming codes of conduct and regulations also later out in 2025 and 2026 and so on as well. I will talk more about that eventually soon as well. But first of all, who does this apply for? So first of all, the scope of which countries this applies for is generally the EU plus EFTA, meaning the European Economic Agreements comprising of approximately 30 countries in Europe, both EU members and EFTA members, such as Norway, where I'm from and where we're based. This is why it's important to consider this as well. It applies for the whole of the European Economic Agreement, even if it isn't specifically an EU-based member. And so how does this apply in general? What does the EU AI Act actually say? And here, the most fundamental pieces to consider is the classification of different risk levels. We have here an acceptable risk, a high risk, specific transparency risk or limited risk, and low risk. So here is especially important to consider where are there unacceptable risk and where are there high risks. So the European Commission, European Parliament considers unacceptable risk, for instance, to be social scoring, facial recognition systems in public, behavioral manipulation, biometric systems, and so on, that uses these systems for a bit more malicious purposes, especially on a high level, such as facial recognition, such as social scoring, behavioral manipulation, and so on. That's where it crosses the line for the European Commission, European Parliament, and that's why that will be completely unaccepted, not accepted in the AI systems that will be developed and accepted forward in compliance with these systems. So, and also important to consider here is that there's no specific threshold for where the EU AI Act applies. So this applies for small and big organizations alike. So don't think just because you're a small company, just because you're a startup and so on, that this doesn't apply to you, because most likely it will. And this is why this is important to consider here. So unacceptable risks to be avoided in general by the EU AI Act, this applies especially from February 2025. As mentioned, this is when the official ban will apply for real. But of course, you don't want to just start now with developing a new system that could have a potential risk of this when for instance, if you develop a 6-month project, for example, and then it ends up in March, April, May, to have some prohibited activities involved in the use of AI there, that is risky business. You should already consider and plan out and prepare for these stuff now, so that you avoid that risk in the future. That's what we think, at least, and I will go more back into the preparation part later as well. So for the high risk, here is important to consider where it falls under product safety legislation. So for instance, if with any use in aviation, cars, toys, etc., where the EU safety legislation applies for the product development, there it is to be considered a high risk in a sense. Also many other applications and use areas as well, specific areas like infrastructure, education, law enforcement, and other fields as well may also be considered high risk. It doesn't mean that it isn't allowed to develop AI systems, but it does mean that you have to be extra careful. You have to put extra risk assessment, risk mitigation strategies and tactics in place when you develop these systems, to be careful when to make sure you comply when these cases, when these things are being developed and implemented in practice. So official codes of conduct or official official code of conduct to comply with the EU AI Act hasn't been released officially yet. This is estimated to be released in May 2025. So then we'll get kind of a clear code, clear guidelines for how to comply with the EU AI Act properly. But before that, we at least consider that it's really important to prepare for these things, especially if we're going and entering into long-term contract. This is important to think about already now for the system and projects we're going into in the coming months. So that means preparation and planning, really critical areas here. This means that we take seriously the planning and preparation phase. We do solid mapping and preparation, see that where are the risk levels of these AI solutions that the client wants or that we're going to deliver to our clients, to our partners, and so on. And then build on that and use the risk assessment to see, okay, no, this may be some unacceptable risk here. Okay, we can't take on that project, or if we're going to take on this project, then it needs to remove this part, or it needs to be adjusted so and so, for instance, to avoid that unacceptable risk. And if it's high risk, extra careful assessments for the risk and mitigation strategies there to make sure we comply with all regulations in place there. Also, beyond just unacceptable and high risk, there's also the so-called specific transparency risk, which means that when you have an AI functionality that it will communicate out to users, for instance with a chatbot that is based on AI, it must inform users that it is actually being communicated with AI, being communicated with a machine and not an actual person. So that transparency risk is also important, especially for these more low-scale AI solutions where there aren't the high risk as with other tools, but you still need to consider that transparency, that this is actually based on AI and not human in this type of communication. So that basically summarizes most of what the EU AI Act is about. Applies for countries within EFTA, especially both for the sale, distribution, utilization, introduction, and so on of new AI development, new AI systems and tools, solutions, and generally there are 4 key risk elements. There are unacceptable risk, high risk, specific transparency risk, and low risk. Low risk hasn't any specific kind of problems or regulations with them. So mainly key and critical here, consider the risk levels, consider this based on the use case, and do solid planning and preparation for when you and your business are going to develop AI solutions like this. So that's basically it for this video. This has been the summary and how to what the EU AI Act actually means for AI solutions in Europe, in the European Economic Agreement, and how to actually prepare for the coming regulation and the coming enforcement of this act in the coming years. So I hope you have enjoyed this video. Be sure to like and subscribe for more videos like this. If you want a review consideration of the type of AI solutions, automation solutions that can be implemented in your business to make sure that it's compliant and actually in line with what your business wants and needs, that also matches the security and regulatory requirements. Be sure to book a meeting with us. You can find the link to book a meeting with us in the description below. Hope you all have a wonderful day, and I'm looking forward to see you all again very, very soon.